An estate plan is the documents and ideas that you put into writing to take care of and transfer your property upon your passing. The reason why it's important is because it allows you to take care of your family both emotionally and financially after you pass. The key components of the estate plan are your power of attorney and a will or a trust. The power of attorney being the document which allows your family to take care of you when you are incapacitated. The will or the trust is the document which transfers the property upon your passing. Some common mistakes that we see in people's estate planning are not doing it. That's the biggest. The second most common mistake is people thinking that putting a child's name on a deed or a bank account is a way in which to transfer property. The problem with that is that when you place your child's name on a property deed or a bank account, it actually becomes a taxable event. Therefore, it's the equivalent of giving them a $200,000 gift upon which they will be taxed. So how do you accomplish transferring your house or your bank account to your children without creating a taxable event? The simplest way to do that is through a power of attorney, a will, or a trust. No taxable event is created by naming your child, your healthcare agent, your power of attorney, or passing the property through a will or naming your child as a beneficiary of a trust. Other common mistakes we see are not signing the will. It is amazing how many people draft the documents and then never get it notarized or signed. Another common mistake we see is not having the will in compliance with the laws of the state. For example, some states require 2 witnesses. If you only have 1 witness on your will, the will is not valid. I was recently contacted by a friend of mine who scanned a will in and sent it to me. He asked me if it was valid because his father had just passed away. I reviewed the will and it looked fine until I got to the last page and realized no one had signed it. It was not witnessed, it was not signed by his dad. And what that meant is that all of the property, a $5 million estate, was going to be governed and distributed by the courts. It would be approximately 3 to 4 years before anyone was going to be able to access the money, and it was going to cost them thousands in attorney's fees. It is critical to review your estate planning documents annually. The reason why is because the laws change, and particularly the tax laws. It is also critical to come in and visit your attorney every 3 years. That way you sit down with your attorney and you go over how you've distributed the property, who you've named as a personal representative or power of attorney. Sometimes you've had grandchildren born. Sometimes you have been remarried. You have sold property, purchased property in another state. If you bought that amazing beach house in Rehoboth, that will actually trigger probate in 2 states if you live in the state of Maryland. That's the type of thing you need to look out for, and having annual check-ins with your attorney and meeting with them every 3 years can make such a big difference in terms of making it easy for your family to distribute your estate upon your passing. Estate planning does not have to be complicated. All you have to do is come in and talk to us. We would love to help you create a legacy of love for you and your family.